Good afternoon, everyone. My name is Brett Van Dam, and I'm a student here at the Center for Public Legal Education, or CPLEA for short. Welcome to our one-hour webinar this afternoon, What Are My Rights on Arrest? I will introduce our panelists in just a few moments. But before we move on to that, the Center for Public Legal Education respectfully acknowledges that we are located across Treaty 4, 6, 7, 8, and 10 territories, and respects the histories, languages, and cultures of the First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continues to enrich our vibrant community. And just a brief disclaimer, this presentation contains legal information only and is not legal advice. Speaking on our funding, we would like to thank our funders, the Alberta Law Foundation, the Department of Justice Canada, and the Alberta Real Estate Foundation for making our webinar series possible. Now, just a few housekeeping items. We will be recording this webinar for on-demand viewing on the CPLEA YouTube channel. Please save any questions you have until the end using the Q&A function. And you may be prompted to complete a short survey when you exit the webinar. Completing that would be very much appreciated. Now, what or who is CPLEA? CPLEA is the Center for Public Legal Education of Alberta, and our goal is to make the law understandable for Albertans. We are a nonprofit organization serving all of Alberta. We provide legal information and education through our various booklets, tip sheets, videos, webinars, websites, and more. Our goal is to make the law available and understandable to empower Albertans to use the law in their own lives. Here's our website. Now, we'll briefly introduce our panelists and give them each a brief chance to introduce themselves. First, we have Janice Garzon, who's a lawyer at Legal Aid Alberta. And we also have Steve Smith, who is a criminal defense lawyer with Steve Smith Law. So, John, would you like to give a brief introduction about what you do?
Yeah, I am currently a bail lawyer with Legal Aid, so I provide a very specific service in helping people get judicial interim release, which is another word for bail. We work in shifts from 8 a.m. to midnight, where we run Justice of the Peace bail hearings, and that's provided free of service to Albertans who have been detained in custody. I also do bridges calls, which is one shift. One day of my shift, I take calls from people who have been arrested. I tell them what their rights are in dealing with the criminal justice system, youth that are arrested. We also speak to people who have been detained under the Immigration Act and people who have been asked to provide a breathalyzer to the RCMP. We also give them advice, and that's free of service, and we run that 24/7.
Great. And what about you, Steve?
I'm a criminal defense lawyer in private practice. I've been practicing pretty much exclusively in the area of criminal defense since 2012. I guess I'm sort of the opposite of Jana. I'm not specialized. I do the full range of criminal defense work. I do trial work, some appellate work. I've appeared in all levels of court in Alberta, as well as the Supreme Court of Canada, where I was soundly and decisively routed. So yeah, I do the full range of criminal defense work.
Yeah, and I can say I've always said if I was charged with a serious crime, I'd call Steve. So I had experience working with Steve both as I was a defense lawyer, he was a defense lawyer, but I was also a member of the federal prosecutions, so the Public Prosecution Service of Canada, where we almost exclusively prosecute drug offenses. So Steve was on the other side of those files, and whenever Steve had one of our files, you knew you had to be on your game and ready to be in a dogfight, so to speak, but a very respectful one. A lot of respect for the way Steve handled his files, but we always knew that there was a good chance we weren't going to win.
I should have been fine if you weren't on your game. I didn't want you to feel like you had to be. I'm sorry for giving that impression.
Great. Now we can move on to our questions now. So our first one here is, what grounds do police officers in Canada require to arrest an individual?
So the threshold is either they find you committing an offense, there's a warrant outstanding for your arrest, or they have reasonable grounds to believe that you have committed an indictable offense. And an indictable offense includes the vast majority of criminal offenses. Reasonable grounds doesn't mean they have to know for sure you committed it. It means they have to have information resulting in what's called a probability that you committed it. So a possibility alone isn't sufficient. It has to be a probability. If you think that sounds a bit vague and nebulous, well, you won't be surprised to learn that what amounts to reasonable grounds in any given case is frequently heavily litigated. But that's the answer: is that the police have to believe on reasonable grounds you've committed an indictable offense.
Essentially, yeah, it has to go beyond a suspicion, but not
Thanks.
too far beyond.
Right. So it's less than being satisfied on balance of probabilities. The evidence establishes you committed the offense, much less than proving beyond a reasonable doubt you committed the offense, but more than merely suspecting you committed the offense.
Great. Thanks. Now, for our second question, how do Canadian rights on arrest differ from the commonly seen American Miranda rights that people getting arrested in television shows are commonly spoken about too?
Well, one obstacle in answering this question is I don't necessarily have a full understanding of what American Miranda rights are. I know most of that, frankly, from seeing it on TV as well. As in the United States and Canada, when you are arrested, the police have to advise you of your right to retain and instruct counsel without delay, which effectively means calling a lawyer from police custody, somebody like Jana, or somebody like me. Unlike in the United States, a component of the Miranda rights is, as I gather, if you can't afford a lawyer, one will be provided to you at the state expense. There's no such right in Canada, and that's accordingly not part of what you're advised. The rights differ a little bit further on too, notably, well, in both Canada and the United States, you do have the right to remain silent. I gather we'll be talking a bit more about that later, but you're not required to talk to police. In the United States, if I understand correctly, once you assert your desire to remain silent, the police have to stop questioning you. Additionally, in the United States, you're permitted to have a lawyer present with you for police questioning. In Canada, neither of those things is true. You don't have to answer police questions, but you can't stop them from questioning you by saying you're not going to answer questions. They can keep questioning you, and you can keep not answering, or you can make the incorrect decision and answer them. Similarly, in Canada, there is no right to have a lawyer present with you during a police interrogation.
Unless you're a youth.
Sorry, yes. Yeah, youth. I don't do a lot of youth work, but youth have an entirely different set of rights. They can contact not only a lawyer, but also another adult of their choosing, and they can have present with them a lawyer or another adult of their choosing.
Yeah, a youth can have both. If they're going to give a statement, they can have both a guardian parent, if those aren't available, another adult, and a lawyer present when they give their statement. But Steve's exactly right about the police being able to continue to question you. And I tell people this, almost every person that calls me that has been arrested, when I'm on Bridges calls, I explain to them in those exact terms, this is not what you see on TV. Just because you said you don't want to speak, it doesn't mean the police aren't going to keep trying. And I tell them the ways that the police are trained to investigate. And I say their role is to gather evidence. They are investigators. They're heavily trained to say things like, we're trying to help you, or, we just want your side of the story. And, or they say, you're coming to the back to give a statement, and you feel like that means that you have to. So I clearly explain to people, you do not have to help the police with their investigation. They have a job. I have a job. My job is to tell you basically to keep your mouth shut, and you will get to share your side of the story, but you're going to share it with a lawyer, someone like Steve, and you're going to share it throughout the court process. Do not share it while you're in custody.
Yeah, I could say a lot about that. One thing that I always tell my clients when they call from custody, this is something another lawyer told me years ago that he saw during one of his one of the recorded police interviews with his clients. He said it was half an hour of my lawyer told me not to say anything, half an hour of, yeah, I really like dirt biking, and then half an hour of tearful confessing. And as Jana says, police are trained to build a rapport. So that's what, instead of talking about the offenses, they started talking about dirt biking. The guy thought, well, there can't be any harm in talking about dirt biking. He got in a back and forth with the officer, got comfortable with him, and then the officer sort of steered the conversation to the actual offense. And despite the fact that the lawyer told them not to say anything, and they clearly understood that advice, the police were successful in listening to confession. They're not by beating it out of them or anything else inappropriate, but simply by in building that rapport.
Mhm. And I tell people too, your phone calls are recorded. Unless you're speaking to a lawyer, don't talk to your cellmates, don't talk to anyone on the phone. And everything you say after speaking to me, because now you've had your right to counsel, is evidence. So there's a difference between what's admissible and what isn't. And some of what's, well, I believe all of what you've said before you've spoken to a lawyer shouldn't be admissible. Some things, sometimes it is. But after you've spoken to a lawyer, everything that comes out of your mouth after that point can be used in court.
And before you speak to a lawyer, it's important. I think we have some questions later on that we get to about the police obligation to hold off on eliciting evidence from a person who's asserted their right to counsel. But if you say something spontaneously, as people very often do, like that is, it's not in response to police questioning. It's just when they arrest you, you spontaneously say, "Yeah, I killed him. I'd do it again." That is admissible, generally speaking. But yes, normally anything you say in response to police questioning prior to being afforded an opportunity to contact a lawyer will not be admissible.
Great. And the next question is we're kind of delving into bail here. What is bail and how does the bail process begin? This will be Jana's specialization here.
So bail is referred to commonly as bail. We call it judicial interim release, which is exactly that. It's being released in the interim, in between your arrest and your trial or your guilty plea, however things shake out in court. But the bail process is when you're detained in custody and then you're given an opportunity to try and get out of custody. And in Canada, they can hold you for up to 24 hours before you have that bail hearing. Normally, we try and deal with things within about an 18-hour time frame. But I tell people when they're arrested, you're likely going to be there overnight. The police do have an option to release you on their own accord. If it's a minor offense, they can give you an undertaking to appear in court and you're on your way. But if they choose to hold you for that bail hearing, you might be sitting there for 18 to 20 hours before you have that. So the police will send the information, the evidence they have, we call it disclosure, to the prosecutor's office. The prosecutor will review it and make a decision whether they agree to release you or they disagree to release you. Then they share that information with a defense lawyer. Usually someone from our legal aid bail team picks up that file and we negotiate with the Crown on release terms. So if the Crown says, I agree to release this person, these are the conditions I want, I will negotiate with the Crown and say, I think this condition doesn't apply. This condition doesn't relate to the offense. This is a theft, and now you're trying to put this person on a condition that they can't have they must surrender all their firearms. And I say that doesn't match up with the offense, and we negotiate. Sometimes we completely disagree. Then we go in front of a justice of the peace when it happens in that way. It can also happen in court in front of a judge. There is a difference between a justice of the peace and a judge. But we go in front of a justice of the peace or a judge. The prosecutor will say, Your Honor, or Your Worship, if it's a justice of the peace, and will say, we oppose the release of this individual. And I will say, I think that they can safely be released into the community. We'll have a little debate. The judge or the justice of the peace makes the final decision. And in Canada, the prosecutor has to articulate very clearly why they are opposed to releasing this person. It's a very high threshold. And there's 3 grounds. There's the primary ground, the secondary ground, and the tertiary ground. The prosecutor might oppose on all 3 grounds. They might oppose on only 1 ground. A person might be held in custody on a theft, a minor theft, but they have a history and a criminal record that says you failed to appear in court 5 times in the last 3 years. That's a primary ground concerned. So the primary ground speaks to whether or not you're going to show up in court to deal with your charges. If you've shown a history that you can't be trusted to do that, they might decide to hold you there. The secondary ground is whether or not they think you're going to commit a further offense if you're released. So the example of a theft, maybe a minor theft, but you have 10 thefts convictions on your record. The court might say, you know what? Every time you've gotten out of jail, you've gone and stolen something else. we're going to hold you on the secondary ground. We believe that a further offense is going to be committed if you're released before your court date. The tertiary ground speaks to the, I see Steve's comment on this one, but it speaks to the public's perception, essentially, of the crime and whether the public would lose faith in the administration of justice if this person were released into the public. So you have someone who has shot an innocent person, someone they don't even know, and they've shot them for whatever reason. If they were released into the public would be appalled because now you've put someone on the street that has killed people at random. So that would be a strong argument on the tertiary ground. So that little debate just had between defense and prosecutor, and it's decided. And your conditions, you might end up with 10 conditions. You might end up with one condition, like a no contact condition. You got into a bar fight. Okay, we're going to release you, but now you can't have contact with that person that you got into a bar fight with. Unlike the United States, we don't have these high bail amounts. It can happen. You get like a Karla Homolka. Yeah, you're going to be put on a high cash bail. But by and large, the amount of money you're asked to pay to be released is in accordance with your income. And we often release people on a no cash bail called the promise to pay, which means that you promise to pay maybe $500. If you breach your conditions or you don't show up in court, then they can come after you for that money, but you don't have to produce the $500 to be released from jail. Steve?
Just on the tertiary ground, I was smiling because, ask any criminal lawyer to explain the tertiary ground. Well, ask any 10 criminal lawyers and you're going to get 11 different answers. So it's important to note that the tertiary ground, it's about public perception. But if the reason the public would be concerned about release is because the person never shows up to court, well, that's more a primary ground issue. If the reason the public would be concerned is that the person is going to commit a bunch of offenses, that's a secondary ground issue. Tertiary ground is really mostly for where there are reasons for public concern that extend beyond those. So until relatively recently, the major Supreme Court of Canada case on this came out of Edmonton. It was a guy named Michael White who was found ultimately to have killed his wife. He was arrested for murder and was initially released. The Crown sought review of that release and successfully convinced the Alberta Court of Appeal that he should have been detained on the tertiary ground. And the reason wasn't that he was going to commit a bunch of offenses. He had no criminal record. It wasn't they were concerned he was going to show up in court. It was basically this guy committed an extremely serious offense, and the evidence that he committed that offense is very strong. So, he's presumed innocent until trial, but at the bail stage, they will sometimes look at the strength of the evidence. And basically, if the offenses are very serious and the evidence is very strong, the thinking is, well, at the end of the day, this person is going to be convicted and sent to jail for a long time. It would adversely affect the public repute for the administration of justice if he was released on bail in the interim, even if we know he's going to show up for court and even if there's not any real danger of him committing further offenses. The tertiary ground is sort of a weird animal.
Thank you for pointing that out, Steve, because I think a lot of people, you read the news, you hear the crime this person's been accused of committing and that they got bail. So you have the public going, oh my goodness, this is a catch and release system. How can someone that did that be released? The strength of the Crown's case is extremely important at the bail stage. So a person might be committed of a very bad offense, but if the Crown knows they're not going to be able to prove it, or there's a slim chance they're going to be able to prove it, there's often an identity issue. So it's an armed robbery, but we don't think we're going to be able to positively, beyond a reasonable doubt, identify the masked robber when it comes to trial. They're likely going to be released. So the strength of the Crown's case is huge when it comes to making a decision on bail.
I'll say it should be huge. I'll say very often the response of the Crown to me going on about the issues the Crown is going to have in proving its case, which I generally turn out to be right about, incidentally, as with most things. Very much their response is, well, that's an issue for trial. This is the bail stage, which great. Yes, trial is where determine whether the Crown has enough evidence to convict the person. But if trial is going to be 10 months down the road, I'd kind of like the court to know that the Crown is short of evidence when it's deciding whether the person is going to spend those 10 months in jail or at liberty. One other case I want to refer to here on bail and the presumption of innocence and the strength of the Crown's evidence. This was a fairly recent one in Toronto that you may have seen in the news. A guy named Umar Zamir, who did drive his car over a Toronto police officer, killing him. He was released on bail, and there was absolutely public outrage that a person who killed a cop would be released on bail. Now, there's generally a publication ban on evidence taken at bail, and the reason for that is you don't want the jury to read in the news about what happened at the bail stage if that could taint their view of the case later when it goes to trial. So as a result, the reasons this guy was released on bail was subject to a publication ban until after his trial. Well, at his trial, it was established, the Crown has to prove the case beyond a reasonable doubt, and it didn't, but I would go so far as to say that the evidence established, I think pretty clearly that this was an accident. That is, the police were undercover. They approached the vehicle. He hadn't done anything wrong. I think it was a case of mistaken identity initially. He sees these guys in plain clothes yelling angrily at him. He's driving a vehicle with his wife and young child in it. He panics a bit, and he does ultimately back over an officer. But there's really no case for murder there at all. Lo and behold, once the publication ban was lifted and we saw the reasons that the court granted Mr. Zamir release, that figured into it. The court said, well, it doesn't look to me like the Crown has a very good case here. And indeed, when it got to trial, sure enough, the Crown did not have a very good case. So that was a case of the system working exactly as it should, other than the part that this even went to trial, because that's frankly, given the evidence that there completely outrageous. But the public doesn't know that. And a lot of political leaders, including Doug Ford and John Tory, who was, I think, mayor of Toronto at the time, they participated in this public outrage of how ridiculous it is that you'd release a cop killer on bail. Well, he's not a cop killer until he's proven to be a cop killer. And at the time of bail, nothing's been proven yet. So anyway, that's a recent illustration of the importance, the strength of the Crown's case at the bail stage. It's Umar Zamir, Zameer, if you want to Google it.
Great. Thanks for bringing that case to our attention, Steve. The next question will be, what happens if someone is arrested without a lawyer to contact?
Okay, so this is again where my role is played with legal aid. Legal aid providing a service of 24/7 lawyer on call, and we take turns with those shifts. So you have a right, first of all, to the counsel of your choice. But at 4 a.m, Steve might not answer his phone. Well, Steve might. He's a diehard, but a lot of lawyers aren't going to answer their phone on a Sunday at 4 a.m. So they give a free legal aid number where you can contact a lawyer on call 24 hours a day. It's free. I pick up the phone and then I help you in that circumstance. And sometimes people say to me, well, I want to talk to Steve Smith. And I say, well, Steve's not available now, obviously, but I will help you with your legal aid application to make sure that Steve is your lawyer when this gets to court. And I might send the defense lawyer of their choice an email saying, heads up, your client has been rearrested. They're going to have a bail hearing, feel free to participate, kind of thing. But if you can't get a hold of a lawyer that you want to get a hold of, we're there to cover that base for you. And we also have interpreters. So that's something special that, I love about being Canadian. If you call and you can't speak English, I will have an interpreter on the line literally within 45 seconds. I can call that line, conference in an interpreter, any language of your choice. We have languages, to be frank, that I didn't even know existed. We have interpreters. So you'll always be able to understand the legal process if you're an Albertan.
Great. Thanks, Jonna. The next question is, how long can the police hold someone before they legally have the right to speak to their lawyer? I think we briefly touched on this earlier.
Generally speaking, not very long at all. Section 10b of the Charter of Rights and Freedoms guarantees the right to retain and instruct counsel without delay. Without delay, the courts have found in most circumstances means exactly that. Without delay, that is, you arrest them, you bring them down to the police detachment, you search them there, and then immediately put them in a phone room to contact a lawyer. Like almost everything else, it's contextual. There are circumstances where police can delay access to counsel if they can't delay access to counsel because they want to question you before you talk to a lawyer or anything like that. But a case that commonly arises is if police arrest you as they're about to execute a search warrant on your house, and they're concerned that if they put you in a phone room, you're going to call somebody to get them to destroy evidence from that house before they get it out. That's a circumstance in which police often delay access to counsel, and the courts have been, I would say, broadly pretty accommodating of police in doing that sort of thing, and that can extend for a matter of hours. But generally speaking, the answer is not long at all. You have to afford access to an arrestee, afford access to counsel immediately at the first available opportunity. One of the leading cases on this is also out of Alberta. It's a case called Taylor from 2014. That was a situation where a person was in hospital after a car accident. They were placed under arrest at hospital, and basically police didn't make any efforts to accommodate the right to counsel while the guy was being treated at hospital, despite the fact he was under arrest. And the Supreme Court of Canada ultimately held no, they had to take whatever steps were available to him, and here they just didn't do anything. So even though they couldn't bring him to the police detachment and put him in a phone room because he was in hospital, they still had to do everything possible to afford access to counsel. And I have, and I'm sure Jana has, taken a number of calls from people in hospital under arrest.
Yes, and I've taken calls from people from a police officer's cell phone because the police knew in that circumstance they would have to give up their own phone to accommodate the right to counsel so that there wasn't a legal argument against delay. You know, someone that's 3 hours from the detachment and there's a right to counsel that should be exercised in the moment. The police have called me from their own cell phone and handed it over to the accused. So it really is somewhat subjective, but the general rule is as soon as practicable. We don't always say as soon as possible, but as soon as practicable.
Great.
And in any case, before you obtain any evidence from them, they can't question you till they've done that.
Otherwise, they should just throw their evidence in the garbage.
Should often do that anyway.
Alrighty. Next question is, if a police officer gives someone a summons, what is required to comply with that?
That's pretty straightforward. So a summons, Jana alluded earlier to the police have the option of releasing you without holding you for a bail hearing. A summons is one way of doing that. In fact, a summons is a way they can get you brought to court to answer the charges without ever even arresting you. Basically, a summons is a document saying, hey, you have to come to court on this date to answer to these charges. It will also often include a day you have to attend a police detachment to get fingerprinted if you weren't arrested and fingerprinted at the time. So what do you have to do to comply? Well, you have to show up in court on the date specified in the summons, and if the summons provides a date for fingerprinting, you have to show up and be fingerprinted on that date. And that's a way that if police don't think any conditions need to be put on you in a bail hearing, and they don't think you should have to post cash or give a promise to pay, like Jana mentioned earlier, a summons is a way that they can make you come to court without going through the rigmarole of a bail hearing. It's generally in your best interest to just comply with the summons. In fact, once you receive a summons, it's not just your best interest, it's your legal obligation.
Yes, and if you fail to comply with the summons, now there's going to be a warrant for your arrest, but this time the warrant will be in a form that says only a justice of the peace can release you. So people think it's not a big deal if I don't show up in court. Well, now you're going to get arrested on a type of warrant where you will legally and automatically be held for bail, that the police officer doesn't even have the legal authority now to release you. You have to go in front of a justice of the peace. And I tell my clients when I was in private practice, I would rather you come to me with a robbery charge and I speak to your bail than 3 fail to appear in court. I have a better chance getting you out on a robbery than I do if you continually fail to appear in front of the justice system.
Great. Thank you. And the next question, which I believe will be, how can someone get their belongings taken from them on arrest back?
So there are basically 2 kinds of police seizures at the time of arrest. There's what's actually properly considered a seizure, and that is police seize something generally for evidence. They'll log it as an exhibit with the police exhibit number and then hold it for court purposes. The law requires that for that stuff, they have to either bring it before a justice of the peace or much more commonly, give a report to a justice of the peace reporting what it is that they seized exactly. From that point, generally speaking, it's the court that decides what happens to those matters. So when charges are withdrawn, it's very common for, along with charges to be withdrawn, the court makes an order about which of those exhibits are deemed forfeit, that is, the person doesn't get them back, and which are returned to the accused. Same as when the accused pleads guilty, there's generally an order like that. Well, I won't get into that case. That's a little complex. The other kind of property is what's called bulk property, and that's so. For example, if you're carrying a backpack on you at the time of your arrest that has a bunch of stuff in it having nothing to do with what you're arrested for, it's not evidence. It's just stuff you were carrying in a backpack, but they're lodging you in cells and potentially ultimately transferring you to the remand center if you don't get bail. They'll take that backpack away from you. They're not seizing it as evidence. They're taking it away from you just for administrative reasons because you can't have your possessions with you when you're in custody. That's what's called bulk property. That they have no legal basis to hold. They have to release it to you. The difficulty is, and we were talking about this right before we went live here, so what they generally do in that case is they'll give you a notification that, hey, we've seized this stuff for bulk property. You have to pick it up within 30 days or it gets destroyed. The difficulty with that is if, for example, you're denied bail and you're held in custody and you spend the next 30 days in the remand center, you're not going to have any chance to pick it up. It might be difficult to coordinate somebody picking it up, especially in this day and age when people don't memorize phone numbers anymore. We rely on our cell phones and you don't have your cell phone in custody. And beyond that, a lot of the time, people won't even see the notification saying that they have this bulk property that they need to pick up within 30 days. Because police will just put that notification with their property, which is stuff they'll receive when they're released from custody, which if that doesn't happen within 30 days, then in the meantime, the property's been destroyed. So that second one is a serious problem. I have a lot of clients who lose a lot of property that way, and these typically are fairly indigent people. A lot of the time they carry a high proportion of their total worldly goods with them. So it's a big deal for them to lose it as bulk property, and that's a serious problem. For things that are seized as exhibits, things like cell phones, drugs, guns, that sort of thing, that's where there's a much more regulated process where the court will ultimately make a determination of whether the item should be returned to the accused or forfeit to the Crown.
And that can sometimes be a bit of a debate between the defense lawyer and the prosecutor, where the judge will ultimately decide. So we look at the report to justice, all the things that were seized, and then when the case has been dealt with, we have a further debate over which of those items should be returned to the accused, which of them shouldn't. So the prosecutor will ask for the judge for what's called a forfeiture order, forfeiting these 10 items, agreeing to give these 5 back to the accused. So obviously, if something's been seized that's illegal to begin with, a gun you didn't have a license for, drugs, pipes, those kind of things, the judge isn't going to hesitate to say, yeah, of course, that's forfeited for destruction. And then sometimes there's a debate, usually over cash. So as a federal prosecutor dealing with drug offenses, when somebody is accused of having drugs for the purpose of trafficking them and then also has $2,000 in their pocket, at first that's considered evidence, the proceeds of crime. But if that person is ultimately acquitted of having those drugs for the purpose of trafficking, they will argue then, as it makes sense, if I wasn't guilty of trafficking drugs, then I'm not guilty of having $2,000 that was from drug trafficking. I want my money back. And, usually they'll get it because we haven't been able to prove our case.
And the legal threshold in those cases, if the accused is convicted or pleads guilty and is convicted as a result of that, if the Crown wants something to forfeit, they have to establish on balance of probabilities that it is offense-related property. That is, in Jana's example, it is more likely than not that the money was the proceeds of drug sales. On the other hand, if the accused is not convicted, if the Crown wants something forfeit, they have to prove beyond a reasonable doubt that it is offense-related property. So if the Crown has just failed to prove that the person was trafficking drugs at all, it's unlikely they're going to be able to prove beyond a reasonable doubt that that cash was the proceeds of drug trafficking.
Great. Thanks for those answers. Next question is someone who believes they are innocent still required to comply with arresting officers?
Usually. And I'll say, I mean, we have the disclaimer about this isn't legal advice, and that's an important disclaimer. I'll say, generally speaking, you should probably always cooperate with an arrest. Now we'll get to the actual law, but I don't want you to think that I'm encouraging you to resist arrest when I say this. So if an arrest is lawful, you are legally obligated to comply with it. If an arrest is unlawful, you are legally entitled to resist that arrest. The problem is this. We talked earlier at the beginning about police, in order to arrest you, have to believe on reasonable grounds you've committed an offense or catch you committing an offense or there's a warrant out for your arrest. That's based on what police know and what information police have. So it's very difficult for you to know whether an arrest is lawful. Arrests of innocent people are lawful all the time if police believe on reasonable grounds, even if ultimately wrongly, that the person committed an offense. So, for example, if a police officer arrests you a short distance away from a store for shoplifting, you might think, well, this is garbage. I didn't shoplift. This is an unlawful arrest. Well, maybe, or maybe the police just got a report from store security that somebody matching your exact description just walked out of there with a bunch of goods. That would be enough to give the police reasonable grounds to arrest you because you match that description. That would make the arrest lawful. So in that case, you would not be entitled to resist arrest. And if you resisted that arrest, you'd be committing a criminal offense. So because it's basically impossible for you to know at the time whether an arrest is lawful or not, the safest thing is always to comply. At law, however, if the arrest is unlawful, if police do not have reasonable grounds to believe you committed an offense, then you are entitled to resist the arrest in the same way that you'd be entitled to resist any other unlawful assault on you. But you can't ever know that. So just comply with the arrest and let your lawyer go after the cop after.
Awesome. Next is, are there citizens arrest laws in Canada?
Yes, we don't use the term we don't use the term citizens arrest so much, but effectively yes. There's two sections of the criminal code that deal with arrest. Section 495 deals with arrest by peace officers, and everything I've said about arrest so far deals with Section 495. Section 494 of the criminal code deals with arrests by persons other than peace officers. The criteria for those arrests are a little narrower. It's not sufficient to believe on reasonable grounds that a person has committed an indictable offense. You have to either see the person committing the offense or believe that they're being freshly pursued by somebody who is entitled to arrest them. So, for example, if you see somebody running away from police, you can then arrest them. Arrests under Section 494 of the Criminal Code actually happen all the time, but they're probably not what you think. The context in which they happen most often by far is loss prevention officers at stores. Loss prevention officers aren't peace officers. They have no greater arrest authority than anybody else does. They can arrest under Section 494 of the Criminal Code if they catch somebody committing an offense. The difference is they're employed for that specific purpose. They have training in that regard, but as far as their legal authority goes, it's the same as anybody else's. One further caution, in Alberta specifically, because of a very old Court of Appeal case called Lerke, Lerke, which came down very soon after the charter came into effect, an arrest by anybody, not just a peace officer, is considered what's called state action, which means that the Charter of Rights and Freedoms applies to it, which means, in brief, that if you're engaged in a Section 494 arrest, or colloquially a citizen's arrest, you better make sure to advise that person of the right to counsel. That's not necessarily the law elsewhere in Canada, but in Alberta it still is.
Great, thanks. Next is, what is the legal difference?
Another important thing.
Sure.
494 arrest. If you do a Section 494 arrest, you then have an obligation to deliver the person into the custody of a peace officer as soon as practical thereafter. So you can't just keep the person in your custody. You have to turn them over to police once you
forthwith. And I think that's a good. It's a little bit of a sidetrack, but what Steve brought up about acting as in basically as a person of the state when you're doing these citizens arrests, even though we don't call them that, is when the charter is engaged. And like I said, it's a little bit sidestepping the arrest process here and rights. But I think just in general, what the public should know is that your rights under the Charter of Rights and Freedom in Canada are only engaged when it's the government that is acting upon you. So people often go to their, like, it's usually in the employer relationship. They say, oh, you're breaching my rights. Well, if it's a private business, they're not obligated to comply with the charter. Like they would be if you worked for the government, you work for the post office. So your rights are engaged by the charter because the RCMP or the city police are acting on behalf of the government. And I really encourage people to look at the Charter of Rights and Freedoms. They often say things like, they wonder if we have amendment rights. Well, what about my Second Amendment? Well, we're not American. We don't have a Second Amendment, first of all, but we have a Charter of Rights and Freedoms. It's been around since 1982, which really isn't that long ago, but that's where these rights come from. Your right to counsel, your rights upon arrest under Section 10. So I encourage everybody to be familiar with that document. It guides your everyday life in ways that you don't even recognize.
So, what is the legal difference between being detained and being arrested?
It can be somewhat nebulous. First thing to note is that the right to counsel we talked about, that arises not just on arrest, but also on detention. In brief, a detention is anytime the police interfere with your ability to leave, more or less. So it can be a physical detention if they grab a hold of you, but more commonly, what's called a psychological detention. And the test for that is whether a reasonable person in your position, sharing your characteristics. So if you're an Indigenous person, you're likely to perceive police in a little bit different way than if you're of settler stock. Whether a person would reasonably believe that they were not free to leave, they were required to cooperate with police. So the effect of that is a person can be detained by police without police having had any intention of detaining them. The leading case on that came out in 2009. It's a case called Grant, where a black man in Ontario somewhere, I think Toronto, maybe wrong about that, was walking down the street, and the police got in front of him on the sidewalk and started asking him questions. The evidence was police did not intend to detain him. As far as they were concerned, he could turn around and walk away. But the courts held that he was detained because a reasonable African-Canadian person in his circumstances would conclude by police blocking his path that he was not free to leave and was being detained. They did not advise him his right to counsel. They questioned him. He admitted to having a gun on him, and that was held to be a breach of his right to counsel, as well as a breach of his right to be free from arbitrary arrest. So that's the test, or arbitrary detention. So that's the test for what constitutes detention. The line between detention and arrest is a lot blurrier. First of all, on what basis police can detain you is lower than for what they can arrest you. We talked about with the arrest, they have to have that reasonable grounds to believe. Jana said earlier that it's not enough to just suspect. Well, that's where we get to detention, because police can detain you on the basis of reasonable suspicion. So if they reasonably suspect that you've committed an offense, they can detain you for that to investigate that offense. They can detain you for a short period. There's no fixed time limit, but the idea is that, for over a fairly brief period of time, they either determine that they have grounds to arrest you, in which case they move on to arrest, or they determine they don't have grounds and let you go. Generally speaking, it's going to involve a lower level of restraint. It can involve handcuffing, but usually won't. It will generally not involve hauling you down to the police station. It certainly won't involve holding you for a bail hearing. They're going to have to arrest you if they want to do that. Generally won't involve putting you in an interview room and interrogating you. So it's really a question of just how restrictive things have gotten and whether it's risen to the level of arrest. The leading case on this is a case of a guy named Robert Latimer. You may have heard of. He had a severely disabled daughter. He killed that daughter. By all accounts, it was a mercy killing. That is, he killed her because he believed that she was in pain, but the law didn't give him the right to kill her, and he's charged with second-degree murder. And one of the several issues that came up at his trial was when police attended his property, they intended to detain him on the basis that a reasonable suspicion that he killed his daughter. They put him in handcuffs, though, locked him in the back of the police vehicle, kept him there for a fairly lengthy period of time. The Supreme Court of Canada ultimately held on that, well, no, that's not a detention. Regardless of what police intended, that had reached the level of arrest. Now, as it happened, the Supreme Court also held that police had every right to arrest Mr. Latimer at that point, so it didn't matter that they'd actually arrested him rather than merely detaining him. But that's an illustration of the circumstances where even if police think they're detaining, the courts will say, no, that's more than a detention, that's an arrest. Grant's a situation, that's the 2009 case I mentioned earlier, where even if police don't think they're detaining, the courts will say, yeah, you did detain them. But it's the line between detention and arrest is not a bright one.
And we've argued these in court as defense lawyers when the police accidentally say, I believe you've committed this crime. I've said, well, if you used the word believe, so you should have arrested him. You didn't use the word suspect, so now your argument that he was just detained goes out the water. So the wording the police use at the time is very important. And I think the most common example of detention versus arrest is in impaired driving cases. This is where it comes up in every single one because you're detained for the impaired driving investigation, but you're not arrested until you failed a breathalyzer. So that's the most common example.
And to make matters more complex, and I won't get into this, but what I said earlier about the right to counsel attaching as soon as you're detained, not merely when you're arrested, in impaired driving investigations is actually an exception to that. But I'm not going to get deep into that because I don't think we probably have the time or possibly the interest. But impaired driving is a heavily litigated and complex area of the law. I had a criminal procedure prof in law school who said we owe our freedoms to impaired drivers. And what she meant is impaired drivers were the ones who were paying people like me to let courts establish the freedom. I'm going to address this question, actually. Somebody just, Mr. Oxford just asked a question here. The questions, am I under arrest? Am I being detained? Am I free to go? If the answers are negative, walking away is permitted. Are these appropriate in Canada? There's no fixed law on that issue, but at the end of the day, because the test for detention is whether a reasonable person in your position would believe that you weren't free to leave, I would say if you ask police, either am I being detained or am I free to go? And if they say, no, you're not being detained, or yes, you are free to go, then I would say by all means walk away. And if they try to stop you, that rather puts the lie to what they said. Generally speaking, where there's a question of whether somebody's detained, they don't actually ask that question, so you're left with a little bit more nebulous evidence. But by all means, if you're ever not sure whether police are detaining you, asking that question is a very good way to establish it.
Alrighty. The next question is, when are police able to enter private property to make an arrest?
Basically two scenarios. I'll back up. So private property, I'm going to treat private property here as a private residence. A business or something would be a much lower standard. Police could often enter on a private business to effect an arrest, especially if it's a private business that is generally open to the public. But a residence, it's very circumscribed. There's two scenarios. One of them is called hot pursuit. That is, if police saw you committing an offense and they're pursuing you to arrest you and you run into a residence, they can go in after you. You're not home free at that point. But there has to be clear continuity between them seeing you commit the offense and you fleeing into the residence. It's not enough for them to have grounds to arrest you and believe you had committed an offense, and then they find you later and then you run into the residence and they can chase in after you. It has to really be continuous from the point of commission of the offense. The other one is what's called a feeney warrant. That's a particular kind of warrant, a particular kind of judicial authorization where the police ask the courts essentially for permission to do something. That's what a warrant is. Where they say that, yes, not only can you arrest this person, you can enter into a private residence in order to effect that arrest. Important to note that that is not a search warrant. They're not entitled to search the residence. They're only entitled to enter in there for the purpose of arresting you. Now, if they see anything in plain view, that's still admissible evidence, but that's basically, without a warrant, they can only enter a private residence to arrest you if they're in hot pursuit after seeing you commit an offense.
Yeah, and if they are, say, in hot pursuit of a murder suspect and they enter the residence to effect an arrest of someone for murder, but they also see a pound of cocaine and drug trafficking paraphernalia all over the house, what often happens then in that case, or should happen, is that the person's arrested for murder and the police will literally stand around and get a search warrant, but stand there, make sure that the drug evidence is now not going to be tampered with. So someone will keep watch over the property, and then another police officer will go and in a very short time get a search warrant signed by a justice of the peace. Now they can start looking for drugs.
Yeah.
So there's a pause in that process.
Yeah, if you see something in plain view, you can then obviously use that as evidence to then get a further warrant to search the residence. But if you're just going in there either on a feeney warrant or in hot pursuit to arrest somebody, you can't be looking in cupboards unless you think they're hiding in the cupboards.
And when we talk about private property, I think people need to know that, we're based on this old British colonial ideal that a man's home is his castle. So we take it very seriously when the police want to enter your private residence. That form of property, you have a lot more rights than your vehicle. So not all of your property is subject to the same high threshold. Your vehicle, you have much less rights in terms of police looking in your vehicle than you would in your house. We look at vehicles and driving rights in Canada as a privilege, not a right. So the threshold is lower there.
There's something called a reasonable expectation of privacy. And basically, if you're alleging an unlawful search, the first thing you have to establish is you had a reasonable expectation of privacy in what was searched. The leading case on that is one where a guy was storing his drugs at his girlfriend's apartment. The police searched the girlfriend's apartment. He brought an application to have the evidence excluded because there was an illegal search. And the court ultimately held, well, sorry, you don't have a reasonable expectation of privacy in the contents of your girlfriend's apartment. A house has the highest, your own residence has the highest possible reasonable expectation of privacy. You do have a reasonable expectation of privacy in your vehicle, but it's a lower one. You have a reasonable expectation of privacy in a backpack you're carrying around in public, but it's a lower one. The house is the absolute maximum level of privacy interest.
Great. Alrighty. When are police? Oh no, this is different. When are police legally allowed to search someone?
I could do an entire seminar on this one. This is my favorite one.
Yes, it depends. That's the answer to every burning legal question you have is it depends. But maybe Steve can articulate it in shorter form than I will.
I'm going to limit the answer. So first of all, they can obviously search if they have a warrant. So if they get a court to authorize a search, they can search. That's the short answer there. But we're talking without a warrant. And because this is about your rights on arrest, and because this is probably the most frequent context in which it arises, I'll limit my answer. There's a concept called search incident to lawful arrest. That is, if police have lawfully arrested you, and we talked earlier about what's required for an arrest to be lawful, they can search you for three purposes, essentially. First of all, to prevent means of escape. Second, to safeguard officer and public safety. That is, they can search you for weapons. And third of all, to find evidence of the offense for which you were arrested. So, for example, if they arrest you on outstanding traffic warrants, they can't search your backpack to see if there are drugs in there, because that has nothing to do with the reasons for arrest. But if they arrest you for a drug offense, they can search your backpack to see if there's more drugs. The scope of search incident to arrest generally extends to the person and anything on their person. So their pockets, a backpack they're carrying, a purse, if, again, the purpose of the search is to either safety, means of escape, or evidence of the specific offense for which you were arrested. It also, if you are occupying a motor vehicle prior to your arrest, generally extends to the motor vehicle. If you're the driver, usually it will be held to encompass the entire motor vehicle. If you're a passenger, generally speaking, it's a little bit more limited to the exact area in which you were sitting. It does not extend to a residence, even if you're arrested in a residence, whether under a Feeney warrant or in hot pursuit. The search incident to arrest power does not extend to searching any part of the residence, just your person and any thing you're carrying. It also doesn't by default extend to cell phones, the specific rules for cell phones. That was a heavily litigated area a few years ago, because people have, again, that higher privacy interest in cell phones because there can be so much personal information on there in a way that there isn't going to be in a backpack or a purse. It takes more to search a cell phone than merely the general power of search incident to arrest. And it also doesn't generally extend to strip searches. That is, even if they think you might be, have drugs in a cavity or something, they can't, as a general matter, under the rules for search incident to arrest, conduct a strip search. There are additional requirements to conduct a strip search or search a cell phone that is found in somebody's possession incident to arrest. So but for things that are covered by search incident to arrest, they don't have to have any additional grounds. That is, they don't have to have grounds to believe there are drugs in your backpack. If they've arrested you for a drug offense and that arrest was lawful, they can search your backpack to see if there are drugs, even if they don't specifically have grounds to believe there are drugs in there.
Yeah, but you don't have to give the police your password. If a message pops up on your phone while you're being detained and the police happen to see it, well, that's not going to work in your favor, but they can't just start digging around in there. And so that people know your rights against search and seizure are under Section 8 of the Charter of Rights and Freedoms. So it's Section 8 that gives us these rights. We've also, especially as a drug prosecutor, had to toss a lot of cases where the police have said, well, I was doing an officer safety search, and they articulated, I was doing an officer safety search. They pat the guy down and they feel something soft in his pocket and pull it out, and it's a bag of cocaine. And I say, well, we have to throw this case out because you obviously weren't looking for a weapon. You weren't concerned about safety. You knew this was likely drugs, and you reached in to grab them. You shouldn't have. Obviously, it didn't feel like a knife or a weapon, so you should have left him alone.
And that's if the arrest was not for drugs. If the arrest was for drugs, then absolutely they can reach in and pick out what they think is drugs.
Right.
Also, she said we have to throw the case out, and that is obviously often the case. I do want to highlight, though, that really what they'd have to throw out is the drugs that were found in the pocket and then additional evidence that was discovered as a result of that. Any evidence they have that had nothing to do with that unlawful search could generally still go into evidence.
Right.
Whereas the Crown may or may not still have a case. I mean, it may be that.
So the charge may stand that they were originally arrested on, but I would throw out the possession charge, but we would still pursue the theft or whatever else was the original cause of the arrest. Yeah.
Great. Alrighty, we're running a little short on time here, but that's okay because I think we're just about wrapped up. One of our last few questions here is, what should someone do if they believe their rights were violated by the police?
Short answer is Tom loves receiving calls like that. Tom Engel's a lawyer at Edmonton who does a lot of. He has a fairly adversarial relationship with police traditionally. The short answer is, if you're charged a criminal offense, talk to your criminal lawyer about the way your rights were violated. That's pretty straightforward. If you weren't charged a criminal offense, it becomes a lot more complicated. You can sue police for breaching your charter rights. You can't in Alberta sue police in small claims court. You have to sue them in the Court of King's Bench, which is much more expensive and cumbersome. And the reality is, in the vast majority of cases that your rights were violated by police, it's not going to be worth it for you to sue. Having said that, that's not legal advice either. I don't practice in that area. You'd have to talk to a civil litigator who does. Tom Engel is one who does do some of that work, though, again, most of the time, I think his advice is, sorry, it's just not going to be worth it to you. But that's the short answer. If you're charged a criminal offense, talk to your criminal lawyer. They can make an issue of it in the criminal trial. If you weren't charged any offenses, though, unless it was pretty egregious, odds are you're SOL.
Mm-hmm. And it may come as a factor in sentencing. If the court decides that, yes, your rights were breached, but this was a murder trial, we're going to let it pass. We're not going to worry about your rights being breached. We're going to pursue this murder charge. It may come into factor at your sentencing.
Alrighty, and that was our actual last question. So we have 3 minutes here for our Q&A. First off, I have
Sorry,
Sorry.
Go ahead. No, go ahead. Yeah.
Can police give an arrestee a deal if they agree to speak with them?
No, that's a good question. No, there's something called, well, they can. There's something called the common law voluntariness rule. This isn't part of the Charter of Rights and Freedoms, though it's linked to the Charter right to silence. Basically, if they want to use a statement a person gives to a person in a position of authority, generally meaning a police officer, if they want to use that statement against them, they have to prove beyond a reasonable doubt that statement was voluntary, which means, among other things, it wasn't the product of a quid pro quo. So if police say, hey, if you tell us everything that happened, we'll charge you with only second-degree murder instead of first-degree murder, that's not necessarily improper. Police aren't necessarily doing anything wrong by doing that, but the consequence of them doing that is the statement the person then gives is not going to be admissible at their trial because it wasn't voluntary. It was clearly the effect of a quid pro quo. I shouldn't say police can't do that. They can do that as long as they appreciate that anything they get out of that, they're not going to be able to use at trial. And sometimes that'll be worth it if they're questioning somebody who's lower down on the totem pole and they want to get information about somebody higher up. Then it might be worth it to them to do that. But anything the person says, they're not going to be able to use against that person at their trial.
Awesome. And does someone have to speak with the police once they've had their opportunity to speak to a lawyer?
No, and that's the first thing the lawyer you talk to will tell you. You have the right to remain silent. That is, it's effectively absolute. If you're arrested lawfully, you have to identify yourself to police. That generally means name, date of birth, potentially address, but that's it. Other than that, you really don't have to tell police anything. Generally speaking, if you're under arrest, you shouldn't tell police anything. So no, you absolutely do not have to talk to police. But again, they don't have to stop asking questions just because you've told them you're not going to answer them. You
And
have
that's
to.
another difference between Canadian and American. You see on TV where the American accused will say, I don't have to tell you my name. In Canada, yeah, you do. You do have to identify yourself. If you don't, you're going to be charged with obstruction. So,
If you're lawfully arrested, it's important to know, or if you're driving a motor vehicle, because that's a regulated activity where obviously you have to produce a license. But for example, police will commonly, and I think this actually is improper, but views on this differ. If they stop a vehicle because they're investigating some offense, they will commonly ask the passengers to identify themselves. Important to realize that unless you as a passenger are under arrest, or unless, for example, you weren't wearing your seatbelt, in which case they have grounds to ticket you or something. Like, unless they have grounds to believe you have actually done something wrong, you don't have to identify yourself in those circumstances. If you're arrested, then yes, you do. But merely, we don't have to carry papers in Canada and produce them to police on request. So unless you're under arrest or driving a motor vehicle or committing a ticketable offense, you don't have to identify yourself to police.
yeah, and that's a
In
good
those
point.
circumstances, you do.
As a person just on the sidewalk, if the police yell out, hey, tell me your name, no, you don't have to give them your name. But
Awesome.
I,
Alrighty. Well,
I don't know if this is G-rated. I did once have a client who answered a police question for his identity with, "My name is Go F yourself." That was an interesting try. He didn't say F. That's why I was wondering if we're G-rated or not. But
well, I think that's a great way to end things off. Seeing we're out of time. No, it's thank you everyone for joining us. Great thanks to our two panelists, Steve and Jonah. Thank you so much for joining us today and answering these
and if I
questions.
could just say, sorry, I'm not engaged in self-promotion here, but if you do go to my website, stevesmithlaw.ca, there is a heading there called "So You've Been Charged a Criminal Offense," and it actually contains a lot of the information we discussed in this panel. So I'm not saying go there and hire me and give me money, but if you want to read in a bit more depth about what your rights are on arrest, I do have that on my page, stevesmithlaw.ca.
Yeah, and if you're interested in anything from Supplia, you can find us online and on social media. You're also able to subscribe to our monthly e-newsletter, which provides updates in the law and our resources. And I believe that a survey link has been put in the chat, so if you do have time to do that on your way out, we would very much appreciate that and hope everyone has a great day.
thanks,
Thanks
Brett.
very much. Thanks,
Thank
Brett.
you very much.
All of our attendees, and thanks, Jana.
Thank you, Steve.
Cheers, everyone.